There is currently I'm not hearing anything, guys.
By the law firm of Clark Hill.
I have had an opportunity to read the letter.
What is your recommendation regarding the objection that was raised?
My recommendation would be that the questioning by Mr. David be limited only to those issues that involve the ethics ordinance. Anything in regards to his lawsuit or questions in reference to his contract should be excluded from this hearing.
Well, what we're going to do is this. First of all, before I ask if there's a motion, I want to let Mr. Ayad know it's not board members' jobs to make objections to questions or rulings. So you've heard what our lawyer recommended. I'm going to be asking the board members if they agree with that. And if any objections are going to be made, we're going to have to rely on you to make them, or Mr. Davis to make them, or respond. We've heard Mr. Longstreet's recommendation. Does anyone want to make a motion?
Can you turn your mic on?
I make a motion to adopt the recommendation of Mr. Longstreet.
Do we have a second?
Second.
All in favor? Aye. Any opposed? Well, we'll move on now to the next item that I had requested. I requested time records. Mr. Davis's time records were brought up at the last hearing. His time records being those records that would be filled out each week, presumably, or every 2 weeks when he completed a pay period. And we did receive them. Has everybody had an opportunity to look at them? I'll be very candid. They didn't provide a lot of inside information to me. Nothing on there about the hours of the day or that would indicate that work was being done before official work hours or after work hours. If anybody has any questions regarding those records, you could address them to Mr. Longstreet. Other than that, we'll move on.
Basically joining in that letter from her counsel on the federal case.
Okay, so we sent you the letter. You sent a letter in support of that. All right. Has everybody had an opportunity to take a look at the documents? Any questions, concerns, or can we move on? Anybody need any more time to look the records over? We've had them for a while. Mr. Regis, Dr. Ford, Mr. Schaefer, Mr. Woods, Ms. Lewis. We're all okay? Well, then I would say that we move on, and if anybody has any questions or concerns regarding those records, we could perhaps ask Mr. Longstreet during the hearing to raise questions about them with Commissioner Scott or Mr. Davis. Now, there was a third area that I requested the parties submit a memo on, or a brief on, or exhibits on, if they chose to. They didn't have to. The third area was that the issue came up when Mr. Davis was testifying about the lack of records that he might have, text or emails, showing that he communicated with Commissioner Scott regarding working hours before regular work hours or after work hours. And it is my memory, we don't have transcripts prepared, but it's my memory that he indicated that he changed phones along the way. He no longer has the phone, uses the cell phone that he used when he was working for Commissioner Scott. He said if he had that, he would be able to go through it and look for all types of internet communications or text communications. In response to that statement of his, I wanted to afford him an opportunity to submit any type of documentation that he may have obtained if he requested those records. So just so that you know, our lawyer, Mr. Longstreet, didn't receive anything. Am I right or wrong?
Did not.
Okay. Ms. Hunter, did you receive any correspondence or communication from Mr. Davis?
No,
Mr. Davis, did you submit anything in response to my invitation? It wasn't mandatory. It was an invitation to get your phone records and submit anything you wanted us to take a look at.
Let me be more direct. He did submit two documents. That was two contracts of current legislative liaisons for Ms. Scott, Commissioner Scott. He did submit those, but he didn't submit any cell phone records and or text messages.
Well, were those the documents referred to under item number 2 from April 18, 2024? Or those new documents?
Those are new documents.
New
That
documents.
he just submitted a few days ago, I believe.
A few days ago? Okay,
Yes.
and what did they contain? You had a chance to take a look at them?
Yeah, I did take a look at them. They were the contracts of Commissioner Scott, Ms. Trice, and the contract for Ms. Colberts. Christina Trice and Ms. Tolberts.
All right.
Two contracts. for-
Well, those really weren't what I invited him to submit a memorandum or a brief on. So he has a right to bring those up during the course of his testimony. Do you feel the same way that I feel about them?
Those two contracts?
Yes. Do they
Results.
shed any light on him working before official hours or after official hours?
It has some probative value in the accusation that he was required to do certain things as a legislative liaison, that he was required to do those things, starts doing certain work hours, and it could have some probative value in reference to whether though it's corroborative evidence that there are current legislative liaisons that are doing exactly the same thing that he was required to do during his time as a legislative liaison. And it can have some probative value as to.
Well, I asked that information, the brief or the records or the memorandum of law be submitted 10 days before today's hearing.
You did, and there
Did-
wasn't one.
Did you get it 10 days before today's hearing?
No.
Okay, well, what we're going to do is this. We're not going to preclude him from getting into those areas if he wants to, but I have a question. I've never seen those. And I'm operating under the assumption that the other board members have not seen them. So at some point in time, could someone, how thick are those records? Are they 2 pages?
2 pages.
Two
And I
pages?
think they were forwarded, I think they were forwarded to the board 2 days ago,
Okay.
to the
Well-
members.
Well, what we'll do is this, we'll have copies made so that all board members will have them in front of them as the hearing progresses. I don't know how we're going to do that, Ms. Hunter. Could you please take care of that while the hearing is proceeding? All right. Lastly, a question came up and I raised it at the beginning of the hearing last month before we even took testimony from anybody, before opening statements were made. I had asked Mr. Davis if at the time he was hired, he was given a copy of the Wayne County Ethics Code, and if he signed the document for it. He said he did. I requested copies of those and they were circulated. They were obtained and circulated by Ms. Hunter and or Ms. Lane. So with that said, I truly believe that everything that I had asked for at the last hearing has been discussed now today. Whether it's been satisfactory or not, I don't know. I honestly don't know why we didn't get the records from Mr. Davis 10 days prior to the hearing, but we've worked something out where we're going to get to take a look at it. Now, with that said, Mr. Ayotte, you indicated that you joined in the letter from that was submitted by Commissioner Scott's attorney in the civil litigation, Mr. Treblecock. You joined in it. So we're going to proceed with Mr. Davis's questioning of Commissioner Scott. We're relying on you to raise any objections that would involve matters discussed in Mr. Treblecock's letter and then your letter of concurrence. Now, Mr. Longstreet, I'm not precluding you from making an objection if you see something that Mr. Davis is getting into that would be precluded by the motion that was passed here by the board today. But I don't like the idea of our council having primary responsibility for that. Just makes me feel a little bit uncomfortable. So if you need anything, Mr. Ayotte, if you want any clarification, we'll give it to you now. Other than that, I believe we're ready to proceed unless any board member has a question or concern regarding the documents that we pulled together for today's hearing.
Chairman, I do have an objection, Mr. Chairman, as to these documents that were presented a couple days ago by Mr. Davis. As the chairman knows, all documents for the hearing were to be submitted months ago, which all parties knew there was a strategy in place and all documents are to be submitted then. He never submitted those documents. You did give an opportunity to add some additional documents, whether it be by memo or on the issue of her testimony, what have you, and limited as to that portion. You also said that if he has any communication in reference to phone or text that have possibly been relevant to this hearing, you allow him to submit them 10 days before. These documents he submitted have neither of those. They're not relevant to either one of these. So I'm going to object to that, especially given that it was submitted just 2 days ago, especially that the board never received it, neither did the chairman receive it. So I'm strongly objecting to that. You shouldn't be able to use these documents and present documents as he pleases throughout the hearing when it suits his purpose.
Well, I tell you what, I share in your objection, but I'm going to let him, I'm going to let them be submitted here. We're going to get copies of them. We're going to look at them. I want to tell you what you didn't mention, Mr. Iad, is that the documents he submitted aren't even, they don't even fall under the umbrage of what I asked for. I asked for communications between him and Ms. Scott, or Ms. Scott and him. And I said, if you have any in your old phone records, if you could request them and get them, showing that you talked to her about having to do work before official work hours or after. We didn't get those, but we're going to move on. We're going to be a little flexible on it. So with all that said, Mr. Davis, are you ready to proceed with your questioning of Commissioner Scott? And I want to caution you, we're not going to go beyond the scope of our board's motion for today. Our board essentially adopted the position that was set forth in Mr. Treblecock's correspondence. He cited cases, and then Mr. Iad's concurrence. Are you ready to go?
Yes, Your Honor. Yes, Mr. Chairman.
I'm flattered that you call me your honor.
But I just.
Not necessary.
But I just wanted to clarify that the documents in which I submitted 5 days ago to the board and to Mr. Longstreet pertains to, are directly related to the allegations with respect to being the designated record keepers. It was not just the 2 contracts, but also the records that was ultimately provided under the Freedom of Information Act from both the county clerk's office and the county commission's office, which is why they were just submitted 5 days ago. The county clerk's office provided copies of Commissioner Scott's campaign finance records with respect to who has been designated as the designated record keeper since she was elected in 2010, which is directly related to one of the allegations set forth.
Well, I'm not sure about that, but I want to stop you right there. I have heard it said by Mr. Longstreet that the documents you submitted were a couple pages. I thought he said 2 pages. Are there more than 2 pages?
There was 2 separate PDFs. It's their contract, which is only, I think, a couple of pages, and then the records from the county clerk's office, which is maybe 5 pages.
Well, we're not ruling on relevance. I don't know where you're going to go with it. It certainly isn't something that I had requested from you.
Right.
But with all that said, Mr. Iad, are you ready? Mr. Davis, are you ready?
Yes,
Let's
Mr. Chairman.
continue with your examination of Commissioner Scott.
Thank you, Mr. Chairman. May I proceed?
Yes.
Good morning, Commissioner Scott.
Good morning, everyone.
Good morning, Commissioner Scott.
At the last hearing, Commissioner Scott, you began to testify that you were elected to the Wayne County Board of Commissioners in August of 2010. Is that correct?
Yes, that is when I started back at the county again, 2010. None
And
of
when
this
you were
has anything to do with what you are alleging, Mr. Davis. Mr. Davis, we have known you since you were a little boy. My staff and I have worked with you over the years and have helped you mightily. Now, you and my daughter and granddaughter know each other well. You told them that you would do it, so you changed the records and everything. I have never asked you or required you to do those things that you're talking about. You did it on your own. You asked for this job, Mr. Davis.
Are you going to let me?
I had a part-time position available at the time. But then when I told my full-time partner, my staffer, that you were coming on board, then she resigned. Because you can resign from this position without any notification. And I remember that the chairperson mentioned that you were fired. I did not fire you. I just did not rehire you.
Can you ask your next question?
Commissioner Scott, I appreciate those comments. When you were elected in August of 2010, you assumed the duties in January 1st of 2011. Is that correct?
Mr. Davis, I have answered that, and I will not continue to answer that.
Well, additionally, Mr. Davis, I indicated before, the board members aren't going to make objections. But we're trying to streamline your examination. Well, no, please, just one at a time. I don't see what happened in 2010 as being really relevant because you weren't working for her at the time. You were brought on board at her staff about a decade later. Please, Mr. Davis, let's do this with as little pain as possible. Ask questions that are relevant to your allegations.
Mr. Chairman, if you allow me, I'm trying to lay the foundation and very quickly, extremely quickly. I was just interrupted, allow her to say what she had to say, which because of the informal nature of these proceedings, that was totally not germane to the question, but I will streamline the questions as quickly as possible.
There you go. There
Thank
you go. Can't ask for more than that.
Thank you. Commissioner Scott, in November of 2020, did you offer employment to me to work for your office?
Mr. Davis, you asked for a job because you didn't have a job. And I just explained that to you. I had a part-time position open and I said, yes, you can have the part-time position because you didn't have a job. And my staff, my full-time staffer resigned. And so then I offered you the full-time position.
At the time in which you offered me a full-time position, was I employed by the state of Michigan?
Not that I know of.
Not that you're aware of? Okay.
Right.
Okay.
Because you told me you didn't have a job.
I'm not going to testify. I'm just going to ask the questions. And in November of 2020, you offered me a full-time position. Is that correct?
Could you speak up a little, Mr.
I can hear.
You
Yes,
got
I'm
to pull your
sorry.
microphone closer to you. You got to have the red light on. There you go.
Can you hear me? Okay.
Now we can,
Yep.
yes.
No, I'm objecting to the mischaracterization of the testimony of this witness, basically. If he wants to ask her directly, again, if in November of 2020, she's offered him a job, I don't think that's what she testified to.
Again, I'm going to ask the same question. In November of 2020, did you offer me a full-time position to work for your office as a legislative aide?
Mr. Davis, I have answered that question. You came to me saying that you did not have a job and you needed a job. And I gave you an opportunity to work, just like I did when I was a legislator in Lansing. Attorney Darnell Dickerson was my staff person. And you needed a job and he gave you a position. But then he told me just recently that he fired you because you did not work.
And again, in November of 2020, when you offered the full-time position, did you receive any resistance or pushback from your colleagues of offering me the position?
Testimony of this witness.
Let Commissioner Scott answer that question if she can. He asked you if you received any resistance from your staff members when you hired him.
I received,
Okay.
I believe I have answered your question, Mr. Davis.
At this stage, Mr.
Excuse me.
Chair,
Excuse me, I do too. Let's move on to a new question. We're not going to go back and forth. Ask relevant questions. She'll give you the best answer she can give you, and we're not going to administer Novocaine and pull teeth here. She feels she answered your questions. Let's move on.
Respectfully, just for the record, Mr. Chairman, that question was not answered, but I will try to continue to move on. And when you offered me the position in November 2020, when did I commence working in that capacity?
I would object, Mr. Chairman, based on this relates again to the federal lawsuit that's pending on appeal at this stage.
Oh, Mr. Longstreet, I'm tempted to rule on that objection on my own, but I feel the other board members are entitled to legal advice. You heard his objection. Do you think that has merit, that the question should be precluded?
Yes. It goes towards why he was being fired in that particular contract. So I would
Okay,
say sustain that objection.
the objection is sustained. Let's move on, Mr. Davis.
At the time of being hired by you, did you require me to handle any matters pertaining to your candidate committee?
Mr. Davis, on your own, you spoke to my granddaughter and said that you would handle it.
And it is your testimony that I spoke to your granddaughter and said I would handle your campaign finance?
Yes.
Prior to me joining your staff, do you recall who handled the responsibility of your campaign finance reporting requirements?
Davis, that has nothing to do with the issue that you have asking me.
Mr. Ayad, I disagree with your client. I think that could be answered very, very briefly. You're nodding your head. I assume you feel
Yeah,
the
I'm
same.
telling you,
Just let-
this is relevant to this hearing.
Yeah.
I'm advising.
Yeah.
I just said to him that it was my granddaughter that was doing my campaign report.
Was your granddaughter the only person designated to do your campaign finance report at the time in which I was hired?
And my daughter.
I couldn't hear. I'm sorry.
He said, and her daughter.
Was there any other staff person prior to me being hired also assigned to do your campaign finance reporting?
Mr. Davis, the reason why I did not renew your contract was because the work ethics and quality of work declined greatly, and accordingly, I cut ties both with you professionally and volunteerism. I have never asked you to do anything that you shouldn't be doing.
With respect to your campaign finance activities, who is your current designated record keeper?
Mr. Davis, I don't think any of that pertains to what you are stating that I required you to do the campaign report. I did not require you to do it.
And this-
I will tell you, I think she answered your question. We're ready to move on. No, what we're not going to do.
I'm not going to go back. So I'm just, because it's informal. That's.
Okay,
that's-
I think she answered your question. She answered it respectfully. Let's continue. Excuse me 1 second. I apologize. Ms. Hunter was kind enough to get the most recent documents that were circulated by Mr. Davis to our counsel, Mr. Longstreet, I believe either 2 or 5 days ago. She's going to pass them out. We'll take a second to do that in case they come up during questioning. You'll have them in front of you. I personally have not seen them. I didn't even know that they were filed.
That's very timely, Mr. Chairman, because the questioning is about to.
Okay. Thank you
Sure,
very
so-
much. Thank you very much, Ms. Hunter.
Hunter, do you have an extra copy? Oh, okay. May I proceed, Mr. Chairman? Or
Yes,
give you a
and-
second?
And Mr. Ayed, I got you. Mr. Ayed. So he's not paying it. Let's move on with the next question.
Say, wait,
Mr. Ayed, I'd wanted to let you know that I just received a copy of your concurrence letter. It's been circulated to the board. Let's go.
Commissioner Scott, who is Juanita Tolbert?
That is my present staff person.
Did you receive a copy of the documents that Ms. Hunter just passed out?
I did.
And one of those documents is a document from the Wayne County Clerk's Office, which indicates that Ms. Tolbert is currently designated as your designated record keeper. Is that correct?
That is correct.
And you testified that she is your current staff member. Is that correct? And Christina Tice was once your staff member, correct?
Well, you said
Mr.
once, we have to have a, excuse me,
Okay.
we have to have a year on that, because if that predates your employment,
Okay.
I'm, Mr. Longstreet and I are going to rule that you can't get into that.
Okay. Well, then I
Mr. Chairman, the same objection and will go far as to these documents. They basically are post his employment. He's talking about current matters.
Well, and not only that, but I think that one of them dates back to 2011, which would predate his employment. So lay some foundation for relevance for what we're looking at.
I keep saying, Mr. Chairman, I was trying to lay that foundation in which you said, move on, in which I was respecting
Okay.
your,
Well,
and the foundation that's going to be laid is the fact that every one of her staffers in that position served as her designated record keeper.
well, I'm going to tell you this. We
So-
had a recommendation from Mr. Longstreet. We had a motion from a board member that we adopt his position regarding relevance relating to the records. What I would tell you is this. I'm looking at one record and it predates your employment by
A
a
decade.
decade. I'm looking at another one that postdates your employment by maybe a year and a half. If you can phrase a question along the lines that you just said, maybe she can answer it shortly and concisely, and you won't get an objection from Mr. Longstreet or Mr. Ayed.
I asked that question and you felt that she answered it when she gave a speech. So I'm asking it again. Commissioner Scott, have your previous staff that you've hired been required to work also as your designated record keeper for your candidate committee?
So not required.
So when you say not required, did your previous staff volunteer to work as your designated record keeper?
Mr. Davis, it was about your work ethics is the reason why I did not rehire you. I didn't fire you, and I never required you to do my reports. You did it on your own.
Mr. Chairman, I would, because she's not answering, I would move on to other
Okay,
questions.
move
And,
on.
because I'm not gonna.
Very good. And you know, I should tell you, I really feel I have an obligation to tell you. We're not gonna let this cross-examination, it's supposed to be tailored.
Oh,
I'm
this-
not gonna let it go on all morning. What I'm gonna do is I'm gonna give you about another half hour or 40 minutes, and then it's gonna be done and over with. You'll be able to call your next witness,
Thank you, Mr. Chairman.
okay?
Yep. During my tenure as your legislative aide, Commissioner Scott, did you have any fundraising events?
Yes, I had a fundraising event, but you decided to do that.
Do you recall the date of the fundraising event?
Mr. Davis, the fundraising event has nothing to do with the report. And I am not going to continue this line of questioning from you. I have did you over the years since you were a little boy. And I don't know why you're continuing to do this. I gave you an opportunity, but you decided to do what you wanted to do. And last week you told a lot of untruths about how you took people out of my race and stuff, which was not true. You did that on your own because that's the kind of stuff you like to do. Yes, my staffer, my former staffer asked me not to bring you on again because you didn't work while I was in the Senate. Now, I'm not going to continue this badgering from you.
Mr. Scott, respectfully, the
Excuse
issue
me, I
concern,
apologize.
the issue, and I'm not going to respond to the commentary. I'm just going to ask you the questions. Do you recall the date of the fundraising event that was held during my tenure as your legislative aide?
At the moment, I don't remember the exact date.
Do you recall where the fundraising event was held?
Yes, but I never asked you to do any of that. I do my own fundraising.
Again,
You decided to get involved.
again, do you recall where the fundraising event was held?
Yes, it was downtown in Greektown.
Do you recall whether or not it was during a weekday or the weekend?
They're always during the weekdays, just before session.
Do you recall the specific location of the fundraising event?
It was a restaurant.
What restaurant?
Call the name of it right at the moment.
Do you have a copy of the exhibits that were submitted to your council with the complaint?
That to that line of questioning as to the documents, you can ask a question.
Well, when were they submitted? Were they submitted within the last few days or was this pre-trial?
Pre-trial.
I believe Mr. Iyer, I'm not speaking for him, but I think he may be talking about documents that he
It's in
submitted
his
prior to
packet
the
of
start of the year.
exhibits.
If you can take a moment to look at the exhibits that were submitted. And one of the exhibits was a copy of the flyer from the fundraising event.
I'm going to say, Mr. Davis, really is an irrelevant line of questioning. I think your question should be limited to whether Commissioner Scott requires you to conduct fundraising activities during your work hours or requires you to do that during, as a legislative liaison. Date, time, location of the event is irrelevant as to whether you were required to organize this during work hours or as a county resource. So limit your questions typically to the organization of.
I will
not
tell
the
you
date.
right now, Mr. Davis, I'm going to sustain that objection.
And Mr. Chairman, with all due respect, if you look at the substance of the complaint for this particular issue, the date, time of the event is directly relevant with respect to the allegation.
Tell me how more about the relevance?
Mr. Longstreet, would that be accurate, what he just said?
If he explains more, but at this point, I'm not convinced.
Already testified under oath at the last hearing that there was no set date. There was no set date and time as to his work schedule. So I don't know how we can pinpoint whether that's during work hours or not. He's already testified that they didn't have a set schedule. So any time as to, there is no set schedule for legislative aid or Commissioner Scott. And that was very clear in his testimony last
Well,
hearing.
Mr. Ayed, I'm not going to rebut what you've said. I do have a recollection of that, but my problem is this. He's got to have some latitude to show what he might have done during work hours or after work hours. And I really honestly believe that generally speaking, government employees are looked upon as probably working from 8 o'clock till 4:30 or maybe 9 o'clock till 5. I'm going to let her answer that question. I think he's entitled to some latitude.
Well, Mr. Chairman, I would respectfully disagree as to government because again, he's a legislative aide. Most of these legislative aid activities happen on the weekends after hours, and he's testified to that. And this
Well, I
is an
tell you
important
what.
part of our case as to that, sir. He's already testified. He doesn't have a set schedule. It's not from 9 to 5. And some of the board members here asked him about that. So if your work could possibly start at 10 or 11 or 12, said yes. So there is no set schedule, just for the record, Mr. Chair.
I'd like to hear from other board members regarding this objection. I don't want it to seem like I'm precluding everything. Does everybody agree? Do the board members agree with Mr. Longstreet's analysis? Because if they do, I'm going to let it go at that. I'm going to accept his recommendation. Mr. Schaefer, Mr. Woods, pardon me?
I agree with Mr. Longstreet's.
Woods,
I agree also.
Dr. Ford,
Yes, I
Miss-
think that there's been no evidence to support that there are specific hours. And that's something I'm listening for, and I haven't heard it. And so I would also agree at this point that there's no established hours.
Mr. Regis.
I agree with
Okay.
Mr. Longstreet.
I'm sustaining the objection. We don't need to go into it anymore. You've got to be very, very tailored in this because we've heard your examination and we've heard her examination up to this point in time.
Also, can I add, I agree also, but I
I
also have,
apologize, I missed
that's
you.
okay. I also have, issue that there's no documentation to validate. I wish you could kind of speak to that in your questioning and kind of.
We've ruled on your objection and I sought the
No,
advice of
my-
I sought the advice of all the other board members.
That's
I'm
okay.
not going to back off it. We don't need
No,
to
no,
make
that's,
you spend more time.
that's perfectly
Yeah.
fine. For the fundraiser that was held in July of 2020, Commissioner Scott, you indicated that you did not require me to assist in that fundraiser. Is that correct?
That's right, Mr. Davis.
And Commissioner Scott, for that particular fundraiser, if you can recall, did I accompany you to that fundraiser?
Accompanied me to a number of places, Mr. Davis, before and after work and stuff.
For this particular fundraiser that was held at the Athenaeum Hotel, did I accompany you to that fundraiser?
Remember whether you did or not. There were times when you drove me and the times when you did, you kind of required that you drive me until finally I said to Mr. Davis, I can drive myself. And so then that's when I did.
And with respect to this July 21st, 2020 fundraiser, did I drive you to the fundraiser? if you can recall?
You know what? I don't recall whether you drove me or not to that particular fundraiser or not. But it was before work hours anyway, and you did not have to go.
For this particular July 21st, 2020 fundraiser, did you require my attendance at the fundraiser?
No, I did not require your attendance. You chose to be there.
At the July 21, 2020 fundraiser, did you require the attendance of any other staff member?
I'm going to rule that as irrelevant.
Okay.
We're not going to get into that. That, look we're trying to be fair within certain parameters. What she did with other staff members is irrelevant. Done. Move on to your next question.
For the July 2021, July 21st, 2020 fundraiser, did you approve of the flyer that was circulated for that particular fundraiser?
Mr. Davis, you
Again,
did.
I'll have to object again as to whether she approved.
That's the next question.
Well, I'll tell you what, if that's the next question, I'm going to let that question go. Ask your next question and ask what you were required to do, or we're going to strike it.
That was the
Okay?
next step. Did you require me to facilitate with respect to the flyer for the July 21st, 2020 fundraiser?
Facilitate.
I'm
What does
sorry.
that mean?
Yeah,
Let,
objection
let,
as to,
let me be
definition
a
of
little bit
service.
more descriptive. Did you require that I communicate with organizers for the fundraiser?
No, I did not. You did that on your own. I have been doing my campaigns for many years, long before you started working for me, Mr. Davis. And I continue to do that today. I have not required you. In fact, you did very little work.
With respect to the July 21st, 2020 fundraiser, did you require me to reach out to any potential donors?
Objection,
No,
ask and
you
answer.
did
Go
that
ahead.
on your own.
With respect to the July 21st, 2020 fundraiser, did you require me to contact any particular donor?
No, I did not. You told me that you knew these people and you were going to do that. I have never required you to do anything for my campaign or campaign fundraisers.
With respect to the July 21st, 2020 fundraiser, was there any communications in which you had with me as it relates to any responsibilities for the fundraiser?
Protection Foundation responsibilities, that's a pretty big word.
Lay a foundation for it?
Yes. Did you have an opportunity to
Oh,
review?
Mr. Davis, can I ask you to be clear in regards to, you say responsibility?
I was
Is it
about
as
to.
a legislative liaison or a volunteer? Because there's two different things we're talking about here. So can you be more specific, please?
Did you have an opportunity to review the exhibits that were submitted prior to the first hearing as it relates to communications concerning the July 21st, 2020 fundraiser?
Is it that you are asking, sir?
Did you have an opportunity to review the email communications concerning the July 21st, 2020 fundraiser that were submitted?
Mr. Davis, that has nothing to do with what you are saying that I have required you to do. I required you to do very little. And I have been doing my campaigns myself for years.
Mr. Chairman, considering her responses to the questions are the same and this body cannot compel her to answer the question in a certain manner, I'm complete.
It's your
I'm,
examination.
I'm finished.
You're done. Now, do you have any other witnesses that you want to call?
No,
Okay. Mr. Ayed, do you have any witnesses that you want to call? And I want to clarify something for you. You don't have to call witnesses. You could make a motion, just like in a civil case or a criminal case. When one side has rested, the other side has the right to make a motion. I'm not urging you to do so, but I really believe that for right now, we have all the issues squarely before us as board members. And I'm not saying that your motion is going to be granted, but we'll consider it. What would your motion be?
Well, first, I think your first question, Mr. Chairman, was whether I had any more any witnesses.
Okay.
We do move for a motion to dismiss this complaint as this is without merit. We've indicated that from day one. We've submitted our written response as to each and every one of those allegations.
Could you speak into your microphone? You're
Yes,
kind of fading
absolutely.
off there. Maybe you could pull it up by you.
Yes, we've submitted our response, our formal response as to his complaints, and he had pretty much 14 allegations, and all of them really were directed at what Ms. Commissioner Scott supposedly made him do and required him to do and things of that nature. She's denied unequivocally each and every one of these allegations in written form, as well as a previous hearing, as well as today. She was clear, she was consistent, she was not contradicting herself. She's done these for so many years. For so many years, she's done this campaign. She didn't need Mr. Davis to come along and require him to do anything. She gave him this job out of the goodness of her heart. She's known him since he was a child, just to try to help him out. That being said, we heard clear testimony, Mr. Chairman, that there is no set hours, and this is just not by us. This is by the complainant himself, Mr. Davis. And there's board members that question him further on that particular issue, which is important to this case. There is no 9 to 5 hours. This is a legislative aid. In fact, most of the hours, I would say, for a commissioner or dignitary, state rep or senator or commissioner, as Mr. Commissioner Scott, and their legislative aid is not 9 to 5. It's after hours, going to events, going to evenings, going to churches on a Sunday, going to barbecues on a Saturday, to attend functions and community events, which normally are held not in business hours. And why is that important? Because again, he can't place any of what communications, although he hasn't submitted any communications that asked him to do anything during these business hours, so-called business hours. But even if they were, he's already admitted there is no set business hours. So I think it's clear that the burden has not been met whatsoever as to substantiate these allegations, Mr. Chairman and fellow board. We feel that this is yet another onslaught of Mr. Davis's continued harassment of Commissioner Scott, and it's very unfortunate. As much respect as I had for Mr. Davis and for Commissioner Scott, I hate to see this happening. And this continued one after from the state to the federal to previous clerk when she listed her name on the commission as running for commissioner, up to this ethics hearing here today. Enough is enough, Mr. Chairman. This has to stop. It has to stop wasting everybody's resources, time, and efforts. We're a public body guided and delegated to address the county's issues and ethics and county government. And I ask that, again, this matter be dismissed. He's not basically met his burden. We haven't seen any communication whatsoever. What we did see is the communication that we presented in our document saying, take those prints to the print shop, not to the county office. Take them to the print shop for the campaign, what have you. I sent, and you have communication from him saying, I've sent this to your personal email, key personal email, not to business email. She didn't use up any resources of the county resource for a campaign. She's been around the block a few times to understand that's not how it works. She doesn't use county funds or taxpayer campaign resources. She's been a state senator. She's been a state rep. She's been a Highland Park mayor. She's been, a county commissioner, a civil servant. Her record speaks for itself. And I ask that this board stop this harassment and dismiss these allegations once and for all.
All right. Thank you very much, Mr. Ayed. Mr. Davis,
I will just-
response.
Indeed.
And what I would really,
Very
I
quickly.
want to ask
Sure.
that you address something.
Sure.
You have the burden of proof in this matter. The board doesn't, Mr. Ayed doesn't. You have the burden of proof, but the burden of proof is preponderance of the evidence. So I'm hoping that when you respond to the motion to dismiss, that you're going to be discussing the burden of proof and what you believe you proved.
Mr. Chairman, in light of the communication in which this board received, and as well as the limited testimony that has been provided, the preponderance of the evidence and the informal nature of these proceedings is a heightened burden, which basically cannot be met due to the fact that a witness is not compelled to testify. Number two, she's been advised by in-house counsel and outside counsel not to provide truthful testimony about certain relevant allegations contained within the.
Well, I disagree.
What-
I'm not gonna, no, please. I'm not gonna sit up here and let you say things that aren't supported by the record. There is nothing in this record that would indicate that she was told by either Mr. Ayed or Mr. Trebelak not to give truthful testimony.
Let me
That's-
correct that.
Okay, correct it,
You misunderstood what I was saying.
Okay,
In
maybe I
terms
did.
of not to provide testimony concerning certain allegations in the complaint, because certain allegations in the complaint are subject to ongoing litigation in both state and federal forums. Accordingly, because she has that right not to testify, and she's not required to be compelled to testify, certain heightened evidentiary requirements cannot be met, which is why, in light of the questioning in which I attempted this morning, I said there's no need to continue the questioning because the same response was given, which is not a direct answer to the question. And so with respect to Mr. Ayed's remarks, I respect Mr. Ayed, I respect the Commissioner Scott, and certainly there is no harassment on my part. In fact, I would say it would be to the contrary. But with that said, Mr. Chairman, I value this body's time and I value this body's resources and the amount of time that have gone into the complaint. And in light of recent developments and the limited scope in which this body can probe into the allegations, as I discussed with your legal counsel, that I am not opposed to withdrawing the complaint in light of the fact of the limited nature in which this body has jurisdiction. I respect the fact that counsel has advised this body and the respondent not to address certain matters, which is her right to do, and which is the bulk of the allegations in the complaint. And in light of that, I cannot seek any legal recourse to compel her testimony because of the informal nature of these proceedings and the language of the ordinance. So therefore, Mr. Chairman, it is not necessary that you proceed to a motion to dismiss in light of the fact that the respondent is not required to answer specific questions. I withdraw the complaint because without the testimony, I would not be able to meet the preponderance of the evidence standards set forth in the ordinance.
All right, are you making a motion? Are you moving to withdraw your?
I
complaint?
move to withdraw my complaint in light of the fact that the respondent is unable to respond to certain allegations in the complaint due to ongoing litigation.
All right, well, what I would say would be this. Mr. Ayed, you've heard what he's had to say. I'm going to be asking the board members how they feel about it, and very importantly, I'm going to be asking Mr. Longstreet, our counsel, how he feels about that offer. What would your position be regarding his motion? He's moving to dismiss his complaint.
Yeah, well, twofold. First, if he's withdrawing his complaint, we have no objection with withdrawing the complaint on the condition that it's with prejudice, meaning that he can't return and argue this particular allegations again in this proceedings. That's one. Two, I would take issue with his position that she was not testifying and this board can't force her to testify. What this board did was limited to the allegations in his ethics complaints, allowed her to testify. She did testify accurately. She was answering his questions, multiple questions. The only thing they said not to stay away from is the federal litigation, again, which is proper, as every council knows that, not to address because that's relevant to the Sixth Circuit that's pending on appeal. That being said, she did answer each and every allegation. We've not only answered orally, but we answered in paper and documents in our response to each and every one of his 14 allegations. So for him to say that she's not being responsive or she's not forced to testify, I would think it was a misstatement, but that's our position on it.
Now, Mr. Davis, you've heard what Mr. Ayad has said. He has said essentially, look, I don't want to walk out of here if he dismisses it today and face it being filed again. I want to ask you in all candor, do you have a problem with dismissing this complaint with prejudice?
But with respect, I mean, the issue with prejudice, Mr. Chairman, with all candor, I don't want to say that this has any impact on any penny litigation. And the use of the word with prejudice always has some legal ramifications to it. To suggest that I'm going to come back and bring back the same complaint would be absolutely absurd, considering the limited nature and jurisdiction of this body. So I can't dismiss it with prejudice because I don't want it to have any impact on any penny litigation, and for them to possibly raise it as an argument, as they've raised it in their objection to her providing testimony regarding certain issues. So I would not agree to do it with prejudice for those particular reasons. I'm just simply saying the complaint is withdrawn, and the fact of the matter is, based upon the 2 hearings in which we've had, in which this body very thoroughly set forth its limited jurisdiction, Mr. Ayad, it would be, I mean, fruitless, absolutely futile to bring back the same complaint to go through the same exercise.
All right, well, very good. I want to thank you for your position. One thing I would like to point out, Mr. Longstreet, I need to ask a question. To my knowledge, and I'm going from memory, I haven't looked over our code, our ethics code within the last 5 minutes. I don't remember there being a section in there that talks about dismissal with prejudice.
There is not a section that talks about dismissal with prejudice. However, the statute does require that if a second complaint has been brought by a complainant and it speaks of the same issue, that the board will be required to dismiss the complaint. So there is something in the statute that is built to prevent this issue.
Okay, well, I tell you what we're going to do. Mr. Ayad, we're very sensitive to your concern. Commissioner Scott, I want to thank you very much for your attendance at the July hearing and here today. I thought you tried to answer the questions as best you could. I disagree with Mr. Davis's characterization of some of your answers. I do. I disagree with that. But we are here today, and what we have to look at when I turn the floor over to board members to make a motion, what we have to look at is whether you have proven your case by a preponderance of the evidence. And let me tell you this. I saw 1 or 2 pieces of paper that were submitted by you. You didn't call any witnesses to support your allegations. You did sign your complaint under oath. Commissioner Scott filed her answer under oath. So where I'm at today is this. I don't believe that we have a provision in our code that allows for dismissal with prejudice, but all board members heard how Mr. Longstreet described our ability to rule on a new complaint if it comes in. So with all that said, I'm not indicating how I feel about the complaint. I would like to ask if there's a motion by anybody regarding where we go from here. Dr. Ford?
Yeah, before the motion, I have a question because
Yes.
there were actually 2 motions on the floor. And there was a motion by council some motion for summary judgment. And then there was a motion from Mr. Davis to withdraw his complaint. And so I think we have to first resolve that issue, whether or not if we're going to rule on council's motion, or if council, I think if we're not going to rule on council's motion, I think council will have to withdraw his motion, and then we can rule on Mr. Davis's motion. But if council doesn't withdraw its motion, I think we have to at least address that motion.
Well, I tell you what, you heard, Mr. Ayad, you heard what Dr. Ford had to say. He said you have a motion on the floor, and I'll be candid with you, you do. You made a motion to dismiss. Mr. Davis countered by saying, look, because of the way this board operates and the limited tools that we have available, he wants to dismiss it. Do you want a ruling on your motion or do you want to go to his motion? I'm going to leave it up to you.
Well, you know, Mr. Chairman, and I appreciate Mr. Farr's position on that. Right. At the same time, I do believe that this board, this body could rule on granting the motion to dismiss based on the withdrawal of the complaint, you know.
Well, I tell you what we're going to do. This is what we're going to do. We've heard from Dr. Ford. Mr. Regis, what would your opinion be? We've got two motions pending. You could make a motion to consolidate both of them, or you could make a motion to support one of them, and let's hear what everybody has to say.
I think Dr. Ford's position is correct. There's a motion on the floor right now to dismiss. Unless council withdraws his motion.
Well,
I don't think that's what I heard Dr. Ford say. I thought I heard Dr. Ford say you could tie the two motions together. Am I right or wrong about that, Dr. Ford?
No, I didn't mean that. I meant that we neither, you know, if council's motion is the first motion that was made and we didn't complete that, so either he has to withdraw his motion or we have to rule on it before we entertain Mr. Davis's motion.
Well, the concern that I have would be this. Mr. Longstreet refreshed our memory collectively on what happens when a complaint is dismissed and then refiled. If he dismisses his complaint and then refiles it, it would appear that according to what Mr. Longstreet read to us, we have the authority to dismiss that complaint right on its face, right on that basis. But your positions have been heard. Let's move to Mr. Woods. What would your position be?
Well, I will concur with the positions of Dr. Ford and Attorney Regis that his motion to
Yeah, I can't hear
entertain the
you
motion
very
to
well.
Robert Davis to
Okay,
withdraw his complaint.
okay, Mr. Schaefer, what is your position?
My position is that I would move to grant the motion.
Dismiss it?
Worry about what might happen in the future. Let's deal with what we got today.
Thank you very much. Ms. Lewis? Well, do we have a motion then? We know Mr. Schaefer's position. We know all of our positions. I will tell you what my position is. It's my position that we should dismiss the complaint based upon Mr. Ayed's motion. But what I want thrown in that motion and included in there is that Mr. Davis voluntarily said he wanted to withdraw the motion, but that we went ahead and we granted Mr. Ayed's motion, because I think that's important. That's important for the future. If he ever comes back and all of us members aren't on the board at some point in time in the future. Mr. Longstreet, would you agree with what I just said?
I would agree and would just simply add that I would recommend that the board dismiss this complaint in pursuant to 40-7 E6A2, which states that the complaint may be dismissed if the complaint on its face fails to say the claim of unethical conduct or there is insufficient evidence to believe that this chapter has been violated. I think on this record, both exist. So I think the motion to dismiss should be granted.
What about tying in somehow so that the record is clear that Mr. Davis moved to dismiss?
I think he just concurs with the motion to dismiss.
All right, let's tie that up in a motion. Mr. Schaefer, Mr. Woods, Mr. Regis, Dr. Ford. I could take a try at it if anybody wants, but if anybody else wants to take a try, anybody else want to take a try? Mr. Schaefer?
Handle it, Mr. Chairman.
Pardon me?
Why don't you handle it, Mr.
Okay,
Chairman?
well, I'll tell you what, I'm going to make a motion. And my motion is that we grant defense counsel, Mr. Ayed's motion to dismiss because of due to the fact that the allegations in the complaint have not been proven by a preponderance of the evidence. And when it was Mr. Davis's turn to respond to Mr. Ayed's motion, he indicated he wanted to withdraw his complaint. So that was his response. So I'm making a motion, I'm tying those two things together. I think, I only think, Dr. Ford, I may have encapsulated what you said, but I may be wrong. That's my motion. Is there a second to the motion? All in favor?
Aye.
Aye.
Any opposed? No opposed? Matter is dismissed. All right, new business. Such other matters as may be properly submitted to the board. I really don't have any new matters. We haven't had any new filings in the way of complaints. I don't have any other matters to be added on, but there's somebody from the Detroit Ethics Board here who wants to speak about matters relating to her board. And I'd invite you up. Could you step up to the microphone? Make sure that you turn it on. Step up closely, speak loudly, begin by telling us your name.
All right, good morning and thank you for this opportunity. My name's Dawn Widman. I'm the senior investigator for the City of Detroit Board of Ethics. And I'd like to personally invite you to our regional conference. It's our second annual conference we're putting together for local boards in Southeast Michigan. It's September 14th from 9 to 3 o'clock. And some of the topics, the location, Butzel Family Center on the east side near West Village. The topics include roundtable discussions on disclosures, training methods, writing opinions, decisions. We're having a hot topics discussion. Robert's rules for small boards, not the big county commissioner boards, but something that to make our life a lot easier on small boards. We're having a mock hearing and we're going to be assigning people roles than they normally play so that we experience all parts of the hearing. And then it's going to close out with challenges and strategies for ethic boards. And it's going to fit in your budget because it's no cost. All
You
right.
can't beat that.
I know. Yeah. So I wanted to add that there is a $15 lunch that you have to pay yourself. The city of Detroit's not allowed to process money and the ethics boards won't do that. So you got to bring $15 cash. Mr. Longstreet has the registration information, correct? And that he would be willing to share. Mr. Longstreet has attended last year. We're always improving. Like I said, it's our second annual. I believe one of your attorneys, Corporation Counsel, Mary Parisian, has attended. So we just wanted to personally invite you.
And we heard it was a very good program last year. All of our board members didn't get to make it. But while you're here,
Yes,
may I respectfully ask a couple questions?
of course.
Do you have subpoena authority? Does
Yes,
your
we
board-
do.
Okay, so you have the ability to subpoena somebody to come in before the board and give testimony.
Yes, and
Okay.
to be interviewed by me as well and provide documents.
All right, next question.
Yes.
You have the ability, does your board have the ability to swear witnesses when they're called before the board? Can they be told, raise your right hand, and do you swear or affirm that you're going to tell the truth?
Yes, we do.
And when you, as an investigator, take a sworn statement from them or have them into your office to interview a witness before a hearing, do you have the right to administer an oath to them?
No, I have been advocating that we incorporate the Office of Inspector General has this, and the name is escaping it right now. They're changing it from, and I apologize for that. It's one matter to another. And it's basically saying that any information we obtain cannot be used forward by other matters. So criminally speaking and things along, I'm trying to advocate that we adopt best practices in our department as it relates to that.
How many investigators do you have on your staff?
You're looking at it.
You're looking at it. Very good. Well, how many attorneys do you have on your staff? Do you just have a Mr. Longstreet or do you have more than one attorney?
Our attorney representation comes from the City of Detroit Law Department, and please take no offense to my statement. We've been going through them like Tinder dates. So we do not have the ability to establish rapport, a basic understanding. Any ethics ordinance has such nuances to it. So that has been a challenge as well. We just had one for a month. He's leaving. We call it welcome to the wall, like in Game of Thrones, because we're just going through them so quickly. We are advocating that we get our own attorney. It has not been met successfully, but we continue to advocate.
All right. Well, could I ask a favor? Would you be so kind as to send an email with the announcement and the information to Ms. Hunter? She does everything for us. She circulates the materials and that.
I'd be
And
glad to.
And actually, that September 14th date, that's just prior to our meeting next month. So I hope we're able to get some board members to attend. And I
We'd
want to
really
thank,
like to have you.
I'd like to thank you very much. I'm going to turn the floor over to any of the other board
Yeah.
members that might
Any
have a question or
questions?
comment.
All right, thank you. If I can get Ms.
Sure.
Hunter's email, that would be excellent. Perfect. Again, thank you
14th.
for your time.
The 14th. And you're going to send her an email so she could circulate it to us. Excellent. Well, let's move on now to public comment. Do we have any people waiting online, Ms. Hunter, for public comment?
Yes, we have one hand raised by President Buffington.
Pardon me?
We have one hand raised by President Buffington.
Okay. You want to put them on for comment? I would just like to inform them that public comment is limited to 3 minutes. Mr. Longstreet, you got your timer on? Ooh.
Ms. Buffington, if you can hear us, you may speak.
Yes, good evening. This is not the actual complaint that would be filed with you all, but we did submit an initial email in regards to something that we questioned that was unethically done by Corp Counsel. I did not have the time frame to file a ethics ordinance complaint with you all because the issue has just arisen. But Ms. Lane can read the email that I submitted on behalf of the court clerks that are sitting in this hearing today in regards to a MOA and MOU issue that was brought forth by Corp Counsel on a vote to the members of Local 1659 on an issue that the county clerk herself has been fighting for to retain and sustain all of her employment. So, Ms. Lane, I'll leave it from here to you to read my comments with the email I sent. Thank you.
Okay, thank you very much, ma'am. We appreciate the comment. What I will tell you is this. I did review a couple emails, messages that we received over the last few days. If they're not a signed complaint, we don't put them on the agenda. You indicated that you might, and I'm paraphrasing what you said, that you might not have had time. There's no prejudice by that. You have a right to sit down and fill out the complaint form with as much detail and as many attachments as you want. We don't have a statute of limitations concerning the filing of a complaint. So if it is your intention to include other information, I would urge that you do so because our complaints have to be signed by the individual filing them. They have to, they have to cite codes within our ethics code that individuals such as yourself feel have been violated. So you've got time. There's no prejudice by it. And I'll wish you good luck on filling that out. And when you fill it out and send it in, we'll take a look at it.
I certainly
Anybody?
shall. Thank you.
Okay, thank you. Ms. Hunter, anybody else?
There are no other hands on Zoom.
Okay, no other public comments. I'll entertain a motion to adjourn. Second? All in favor? Any opposed? Nope. We're adjourned. Thank you very much for everybody's attendance and participation.